Good afternoon. My name is Oliver Westmoreland. I am an ISC registered Level 3 Immigration Advisor and I am Senior Immigration Lawyer with GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so that you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is this. Born in the UK, who is born a British citizen? And for that matter, who isn't? Now, there was one very well-known rule. Anyone born in the UK before 1st of January 1983 is almost certainly born a British citizen. 99.999% certain born a British citizen. Just a few very odd little exceptions. However, with the British Nationality Act 1981, which came into effect on 1st of January 1983, everything changed, well, pretty much. From that time, the law is completely different. The law is the modern law, we might say. The law is now, if you're born in the UK, at least one parent is British or settled, you are born British. If they're not, then you're not. Moving on just a bit, you're born in the UK, neither parent entitles you to British citizenship, but whilst you're still a child, at least one of your parents acquires a settlement of British citizenship, you can register as a child as a British citizen. A lot of people know this already. I want to introduce something just slightly more complicated. It's to do with the EU. Now, as you know, everything to do with the EU is completely and horribly complicated, and this is no exception. A lot of people don't know this, very probably, but for a certain historical period, Europeans who were in the UK on free movement principles, they were deemed to be settled, more or less. Free movement, this is what we had done before Brexit, if you're old enough to remember. Before Brexit, Europeans, EU nationals, EEA nationals, Swiss nationals could come into the UK very easily just by waving their passport at the border or their ID card. They could come on holiday, they could retire, they could work, they could study, they could come and search for jobs, they could come in all sorts of ways. It's a free movement, it was very free and easy. And it was the same for British citizens. They could travel to Europe in a similar sort of way. It was very free and easy. As we know, Brexit happened. Free movement no longer exists. Strange and interesting fact, difficult to explain. At some historical period, the British government or the Home Office took the view that Europeans who were here under free movement principles were settled. That was the view and the understanding. This crucially important period is 1st of January 1983, Big Bang date, and 1st of October 2000. Now, there are loads of complicated exceptions. It's like everything with EU law, but that's the basic idea. European person, EU EEA, not Switzerland, interestingly enough, European person in the UK between 1st of January 1983 and 1st of October 2000, they were understood to be settled in the UK. 1st of January 2000, suddenly the government changed its mind, or the Home Office changed its mind. No, they're not. But up until then, that was the established legal understanding. They were settled. They had no further time limit between 1st of January 1983 and 1st of October 2000. No, you know that if you are born in the UK, under the modern law, as I just explained, under a parent who holds settlement, you're born a British citizen. So this means, with loads and loads of exceptions, a child born in the UK between 1st of January 1983 and 1st of October 2000 to a European parent or parents who were exercising free movement rights was actually born a British citizen. There are loads and loads of qualifications. I've got them all here. They're too complicated for a normal person. Some countries join the EU at a certain time. Sometimes free movement rights applied at a certain time only. There's loads and loads of complications. If you want to consult a good lawyer like Mr. Shah, he can give you detailed about this. But that's the general overarching principle. Parents in the UK, Europeans, not Swiss, other types of Europeans, EU, people from EU members states, EEA states, which is a few extra ones like Norway and Iceland and Liechtenstein. This person, the parent, was considered to be settled under the interpretation of the law that existed then. Child born then is a British citizen. And this was codified into the law. Got here. Section 50B of the British Nationality Act 1991. This is a recently introduced thing. It says it pretty straight here. Simplify it a lot. It talks about the remedial period. This is this period, 1st of January 1983 to 1st of October 2000, remedial period. A person who has free movement during that remedial period and subject to all these complicated qualifications, they are deemed to be settled in the UK. Doesn't say it here, but it follows on naturally. Child born of such parents is a British citizen. Does that make sense, Mr. Shaw, or do you have any arising questions?
I do have questions. I mean, nationality area is quite complicated.
Yeah, you're absolutely right with that.
It's so much complicated, but it's always best to engage with a professional to get advice on that. Now, you mentioned that if a child is born in the UK and one of the parents is either settled or have a British nationality, they can pass that on to the child.
This is normal rules, yes.
Exactly. What happens when both of the parents do not currently hold settlement? Does the child get the same sort of visa the parents may have?
No. Yeah, it could be a dependent. Parents have a working visa, child get a dependent visa. Yes.
And I mean, we know about that 10 years route to citizenship for kids, for example, if they're born in the UK.
Mr. Sharp, you're introducing a whole new level of complexity. You are right. A child born in the UK, whatever the parent's situation, they live in the UK for the first 10 years of their life. They can apply to register as a British citizen on that basis. This is a special 10 years. I mean, this is a different subject, but you're right.
Sure. And from the same area, if the child has travelled abroad in the 10 years for a short holiday with parents, that is okay, isn't it?
It's fine, a short holiday. But there are rules about how many days you spend outside the UK, as for most British citizenship applications.
Sure. And another question that may be related a little bit to the current topic. If the child is born outside the UK and let's say at the birth of the child, one of the parent is a British citizen, are they able to pass on the nationality to the child?
You've taken so far outside. Look, if the parent is British otherwise than by descent, which is the best and stronger form of British citizenship, the child is born British but not British otherwise than by descent. The child is born British by descent. To be British otherwise than by descent, well, you're born in England of English parents, perfectly, completely British citizen. You achieve naturalisation. You are British otherwise than by descent. Maybe you're adopted. That is the better form of British citizenship. British citizenship by descent comes in various different ways, including that you are born outside the UK. If you're born outside the UK, you will always be British by descent. You will never be British otherwise than by descent. And following from what I said earlier, if you are British by descent in your parent of a child born in the UK, you cannot transmit your British citizenship to the child. It only transmits once. In that narrow sense, British otherwise than by descent is strong. In that narrow sense.
Okay. You mentioned about European nationals exercising their free movement in the UK and having a child in the UK who would have been, British by birth. And it's very possible a lot of parents maybe did not know that.
Yeah, I think a lot of immigration lawyers are not fully aware of this law, to be quite honest with you.
Sure. And let's assume somebody watches this video and they realise that their child should have been British already.
Well, if the child is British, they are British.
They are British.
The law is what it is.
Exactly.
So you can apply for the passport for the child.
Great. So is there any...
Can I just add a few things? There are lots of complexities. You really need to take good advice from a good lawyer. First of all, some countries, they qualify at certain times and other times they don't. And another archaic discriminatory rule is If the qualifying parent is the father, he must have been married to the mother. This archaic rule still exists.
Wow.
And so really, I say to a potential client, don't just rush ahead and make the passport application for your child. Get advice from a good lawyer. Make sure that your child really does qualify, because otherwise you're going to raise the passport application fee.
Sure, and the stress of going back and forth with the passport office.
Exactly.
And would I be correct in assuming there is no sort of limit that one can say that, you know, it's been 10 years and I can't apply now?
No. If you are born British, you are British. You just have to prove it.
Regardless of whenever you may realise it.
Yeah. Yeah.
Okay, fantastic. Well, this was really useful insight, and we thank you for today's vlog.
It's my pleasure, as always.
Fantastic. We see you in the next one.
See you next time.